mention. It was such an important issue. I teach as an adjunct at the Aggie Law School, which uses small words and simple concepts. We had 26 students who very much wanted to be involved in the public process and realized this was going to be an important issue. And so they spent an entire semester doing 50 state research on eminent domain issues across the country and produced this report, which is free and it's available online. I brought a handful of them. But attorney's fees, for example. They determined that many, many states in the United States have an attorney's fee provision protecting their landowners, but we do not, which is a very, very persuasive fact. There's no reason why Texas landowners should be treated any differently. Okay, let's jump into the legislative process this last session. We have, as I said, a Senate side and a House side. Senator Colcourse carried 740 on the Senate side, and then Representative Burns from Johnson County carried House Bill 2684. One thing I just want to note to you is the number of co-authors on that bill on the House side. Look at that. This is a large number. But I will tell you, it somewhat underscores a little bit of the difficult complexity that we had. These were not outrageous asks on the part of the ag and landowners community. But I will explain to you towards the end that they were deemed by some in the condemnation industry as just too much. They like the world the way it is. And so even though you see many, many co-sponsors there on the House side, this group and landowner groups needs to be much firmer, in my opinion, with their representatives on the fact that these bills do need to be passed. Because our group probably spent 2.5 months, weekly meetings with all of the coalition who condemns, which is counties, cities, TxDOT, Pipeline Association, oil and gas, all of them. Working out compromise language, and we really had most of that done. But when we got 2/3 of the way through the legislative session, there were groups within our opposition who felt like this was giving away too much to the Texas landowners. And so they worked very hard to begin to rewrite and undo these compromises that we had reached. Now, Senate Bill 740, just to give you an idea of what was in there, the second bullet point there talks about the minimum easement terms, but the attorney's fee section, if you remember back session before last, Senator Colcourse passed that in the Senate. Couldn't get it through the House. So this time, one would think, okay, we passed it in the Senate last time, we're bringing it back and passing it again. Attorney's fees to landowners was the #1 target by the coalition who opposed these reforms. They messaged to legislators, to the public, and to the business community that this was an effort to roll back tort reform, that this was going to bring in Texas trial lawyers to the eminent domain process. I will grant it very effective in Texas political environment to say that. Not true. Not true at all. They viewed what this legislation would have done, which was had to ensure landowners who are condemned actually don't come out of pocket for their attorney's fees, but twisted that in many legislators' mind, who unfortunately are not as dialed into this issue as they should be, and said, hold on, this is going to be a gift to lawyers. And so it's a very difficult task, and I want to level with you here today. It's absolutely something that Texas landowners need. There's no reason that your property should be taken and that you should lose money on that by having to pay a lawyer. But they are going to continue to message on that front, so we are going to have to reach firmly and often to legislators to say, look, that is poppycock. If I get condemned, I shouldn't have to come out of pocket on my attorney's fees. There's just a reference. The minimum deed terms was for pipelines and transmission lines. We made a strategic decision that we did not want to take on all of the governmental entities and TxDOT on these minimum deed terms, because these easement forms that are not good for landowners, while there may be some governments that play that game, the pipelines and the transmission line companies are the worst offenders in that, and they're the most complex. Okay, so as I told you, even though we spent 2/3 of the session meeting and working out literal compromise language on all of this stuff, what happened there as we were meeting in the Capitol nearly night and day, so the legislators just locked you in a room, and I've almost had all the arrowheads pulled out of my hide since the session was over. But here's what happened. Senate Bill 740, the attorney's fee provision, totally taken out. Just disappeared. Then secondly, the third-party evidence, what I told you about a landowner's ability to go into a commissioner's hearing and introduce evidence of other sales, maybe a neighbor, maybe 2 miles over, that was removed. Initial offers based on county appraisals were added. We had a lot of back and forth with this group, and I want to give you some insight, which is a little surprising to me, that of this broad coalition that opposed us, there were many of them who recognized in meetings that they had a huge problem. And that problem is the growing opposition to eminent domain as a process. You can think back, if you read about the high-speed rail and all the trouble that they had in this, they know if they don't answer this question for Texas landowners, someday it's going to be their project. So we pleaded with them and told them that you've got to do something about these lowball offers that you're handing the widows and the farmers out there on the back porch who don't know any better. They came up with a series of solutions, I will tell you, which is creative, but they wanted to base initial offers on the appraisal district number. And we just sort of politely laughed and said that is a wholly unreliable number. An appraisal is the only way to go with that. But they don't like the appraisals, they don't like the cost of appraisals, and oftentimes it's too much truth. Pipeline Association acknowledged to us in the meetings that they get over 80% of their easements before a landowner ever gets a full appraisal. Think about that. That's not by accident. They didn't have to spend the money on an appraisal, and the landowner signed this easement, which is a permanent restriction on their land, and they never got the benefit of an appraisal. So that's a big problem. So we did not take that bait, and we told them that that is really not going to work. The minimum easement terms, their response to that was that they want, instead of being obligated to hand a landowner an easement with those terms in it, they said, well, we'll just give them a notice. Okay? We'll just give them a piece of paper that says, oh, as a landowner, you can ask for the following things. And sometimes to a legislator, they may look at you and think, well, what's the difference? It's a big difference. Because most landowners, you can hand them a sheet of paper that'll tell them 25 things to ask for, but they're in the midst of a very complicated, stressful negotiation. Those terms should already be in the easement term. They should be obligated to ensure that they're being fair with the landowner, not expecting Texas landowners on all these back porches to have to figure this out and fight their own battle. Insurance provision that condemnors must insure landowners against liability during construction. They took that out. Cost too much, they said. You may be surprised to think if they come in and take your property and they're going to put a project up there that some magic power is going to provide insurance to your property. It's just not the case. But absolutely, if they're using a state process to come onto your property and build a for-profit project, you should absolutely have insurance. And then I mentioned the bond there. That's just a storm picture for effect. The equal appraisal doctrine. And this is just, Joey can tell you how this works, because it works this way all the time on legislation. You have to be very careful what you ask for, because they'll twist it around. The game I told you about where the condemnor doesn't have to provide the appraisal to the landowner 3 days in advance, we asked for that, and it was in the initial legislation. They reworked that around where the final product would have possibly prevented a landowner from testifying in his own special commissioner's hearing. okay? Totally unacceptable. We wanted fairness, we wanted equal treatment, but they rolled it around where it would end up being negative for landowners. I talked about those last two. The bond on appeal, they understood it, but really felt like that, it wasn't something that seriously needed to be addressed. Interestingly, recognizing how much trouble they realized they're in, they brought to the conversation, they said, we want a landman certification as a part of this bill. And we said, okay. You do one of those things where your opponent is asking for something you think is good for you, and you think something's wrong. But they really were genuine about it. Part of that is that they wanted to project upon landmen that landmen are the problem. The door knockers, the back porch guys. And there certainly are some bad ones, but that's not really the problem. But they wanted a landman certification training and some enforcement vested in the Texas Attorney General. And we did not oppose that. The last point there, 10% or an appraisal up front, which was a creative suggestion on their part. We wanted an appraisal for a landowner from the very first time they get a knock on the door, and they were unwilling to do that. But they said, well, how about if we give 10% of the value that we calculate to the landowner up front in cash so they can go to town and get a lawyer or hire an appraiser? And we said, well, okay, tell us more. So we fleshed all that out. But you will see that as time went on, they ended up removed. We said it's got to be a floor of $1,000. I mean, it has to be at least $1,000, no matter how small this is. And it said it's got to be $25,000 if you're going to have a cap. They insisted on a cap because you can imagine on some of the ranches that are down here, these are enormous. And so the money had to be real. But they ended up, the opposition came back and said, we're going to remove that $1,000 floor such that a landowner might not even get $1,000. And so that's just how that went. And that just absolutely vanished. I talked about the value on CAD. Give you a little idea how this works. Everybody forms a coalition. We formed a coalition of our groups, 31 members. They formed their coalition for critical infrastructure. You get it? Texas miracle. You need power, you need transmission lines, you need oil and gas, all of that stuff. Very fair point. Those are the primary members. They had many other members. But when you start thinking about condemnation, pipeline's probably number one on this group's list. Transmission lines number two, but you don't think about it. Cities, counties, Texas Department of Transportation, universities. There's a lot of players on that other side. But those are the groups: Texas Civil Justice League, TexOGA, and Texas Pipeline Association, who I will tell you were the most forward-leaning in opposing these reforms that we asked for. This is how it works. You go to a hearing, and I'll be perfectly candid with you. I spoke to the Texas Wildlife Association. I'll be as frank with you as I was with them. You've got to come. It's a long way from Austin from here. And they hear from people like me, they hear from people like Joey, and they hear from associations, but they don't hear from enough landowners. You've got to come to the hearing, you've got to ring their phone. You all know these legislators, and you've got to tell them, look, don't come home until this is fixed. Because it's hard. If you pit agriculture, landowners, and ranching against oil and gas, you've got the biggest fight that Texas has. But we have to do more at leaning into our legislators. The day before the hearing, this is what went out. It didn't say, we're ready to compromise, we want to help Texas landowners. It says, please vote no. That went to the Senate. Eric, who's over here, provided excellent testimony. We had some very good landowner testimony. But honestly, from now on, when we do this next session, we need a line of trucks out there, and we need people walking in there saying, I'm going to talk about, what's happened to me and what needs to happen. Switching gears just slightly, rounding out the eminent domain. Does red mean you're over? That means stop, right? I never saw a yellow. Okay. I'll take a ticket. All right, 1 minute, because this is important. And is this case. If you do not know about this case, you need to, because it came out of this association, and my point in raising it is to brag on this group. Forest Oil, the El Ruscio land, the McAllen. This case worked its way up to the Texas Supreme Court. Arbitration verdict, large verdict in favor of the ranch for contamination of the ranch by oil and gas. But the issue became this oil company, like all oil companies, very much wanted out of that big verdict. And the question they raised to the Texas Supreme Court, they said the Railroad Commission should have exclusive jurisdiction over any contamination of a ranch in Texas. What that means is that you could not go first and sue them. You have to just call the Railroad Commission and hope for the best. And that was a very, very dangerous position that the parties that Forest Oil was raising with the Texas Supreme Court. Because if Texas Supreme Court had answered that the wrong way, and you had any contamination on your property, you would have to wait for the folks on the Railroad Commission to fix it. Bragging on this association, Susan and the board of this group said this issue is too important not to chase. So it, along with Cattle Racers, Texas Wildlife, and several other groups, said we're going to take it on. And we prepared a brief, filed a brief, and ultimately the Texas Supreme Court came out, and we were nervous that they were going to come out the wrong way. But they came out the right way and told Forest Oil, absolutely not. There is no exclusive jurisdiction. So sorry I overstayed my welcome. It's very nice to be here with you all.